Thank you, May. Now we have Avvy.
Can you hear me at the back? Thank you very much, and thanks, Mr. Justice McMurtry, for your kind words. And I want to specifically thank David. Because of him, every time I take this, more the bus than the subway, because there are only so many subway stops. After 20 years, we still haven't had any new subway. But every time I take the bus, I thank David. Because of him, I know exactly where I'm going to get off. So, as you can tell by now that the theme is, while we're celebrating 30 years of the Charter, there are still a lot of struggles in the community. There's still a lot of issues, particularly issues around racism, discrimination, facing different marginalized groups. So as we celebrate, we also need to take stock. And there are many people of influence in this room. We have Human Rights Tribunal members, lawyers from various clinics, and I do hope that the comments that are being offered today will be taken back as you deliver your job on a day-to-day basis while you're making decisions that affect people in the low-income sector from the various marginalized communities. My job today is to talk about some of the issues that are faced by our clients at the clinics. And because of the time limit that I imposed on myself, I'm just going to focus on immigration area. And I'm also going to talk a little bit about the barriers in accessing legal services in order to advance the charter litigation. And because our clinic serves low-income people from the Chinese and Southeast Asian community, so the issues that I talk about will have a more disproportionate impact on those communities. But I guess I will start by saying that despite Canada's image as a multicultural and some would argue a post-racial society, racism, particularly systemic racism, is still very much alive in Canada. And although we don't have overtly racist laws, such as the Chinese Head Tax and the Exclusion Act, but as May mentioned, the fact is there are various areas of laws that still affect our community in a negative way. And since the Conservative government came into power in 2005, there have been many changes in the immigration law area. We have a very, very hardworking immigration minister, and he's probably the most hardworking ministers on Parliament Hill. And so under his watch, the immigration system has undergone fundamental change from a system that focuses on permanent residents to one that emphasizes guest workers, and from a system that embraces family unification to one that is catered towards privileged young professional English-speaking people, preferably from Ireland. So to start, the number of temporary foreign workers in Canada has more than tripled in the past decade. Most of the temporary foreign workers are racialized, and they are employed in low-paying work with little protection. And in 2003, the total number of guest workers in Canada was just over 110,000. By December 2010, that figure is increased to 282,000, more than the total number of permanent residents who were admitted into Canada in that year. At the same time, greater emphasis and greater requirements have been put on family class sponsorships and even greater restrictions on who gets in as family class members. So for instance, increasingly restrictive financial eligibility requirements have barred many low-income Canadians from sponsoring their families overseas. And as we learned from Grace Edward, racialized communities, recent immigrants are overrepresented among the poor. So the financial requirement has a disproportionate impact on these communities as well. And of course, because immigrants from Asia in particular and many parts of the global south are more likely to apply through the family class stream, and they are also more likely to adopt an extended family structure. So the changes to family class immigration have the added desired or maybe not desired effect of restricting immigrants from these countries. And late last year, the Canadian government actually put a moratorium on the processing of all parents and grandparents' applications and replaced it with so-called super visa system for parents and grandparents to come to Canada to visit. However, those who apply must pay for costly private health insurance, and they must still meet the low-income cutoff requirement. So the changes actually affect many immigrants from Asia who make up a large proportion of parents and grandparents applicants. Changes have also been made to the spousal sponsorship program, resulting in spouses in genuine relationship being denied permanent residence. And before the changes were made, the minister actually visited India and in China with the purpose of quote unquote cracking down on fraudulent marriages. So there's no misunderstanding as to who are being targeted by these changes. And if the minister has his way, he will introduce a new conditional visa on all sponsored spouse so that they have to stay with their sponsor for 2 years or lose their permanent resident status. And if passed, the change will effectively trap sponsored immigrant women in abusive relationships. And I remember the first test case I actually did at the clinic was about sponsored fiancé, because we used to have a law where women had to marry their fiancé within 90 days after they come to Canada, or they will be deported. And of course, many women that we saw at the clinic, they were afraid of being deported, but at the same time, they don't want to stay in a relationship that was very abusive. And so we actually launched a charter challenge, and sometime after that, the law was changed so that there was no longer the requirement, and now it seems like we're going back 20 years by introducing this new law. The minister has also started to implement Bill C-31, as mentioned, the Protecting Canada's Immigration Act, to overhaul the refugee determination system. The new system creates different categories of refugees from different countries. They bar certain groups of claimants from appealing decisions, negative decisions. It hastens the processing time and gives the minister more power to detain claimants, including minors over the age of 16. It also imposes a 1-year ban on failed refugee claimants to make humanitarian and compassionate application, as well as the pre-removal risk assessment application. This new law is definitely clearly discriminatory, as it creates a 2-tier refugee determination system. And the new unrealistic timelines will be hard for all refugees, but particularly for vulnerable refugees such as women fleeing violence, as well as LGBTQ refugee claimants. It is harder for them to make a claim within that strict timeline. And of course, to make the matter worse, Legal Aid Ontario has recently announced drastic cuts to certificates for refugee cases, effectively denying many refugees legal representation. Another change that has been passed, as mentioned, is the new requirement for citizenship applicants to provide upfront evidence for their language ability, which also pose an impediment, particularly for women who have less access to education in many of the global south. And finally, the vaster Removal of Foreign Criminals Act. I love this government. They come up with all these like really fun, titles, and that will facilitate the deportation of permanent residents who have been convicted of just one crime and sentenced to 6 months in jail. Of course, these are all issues that can be challenged under the Charter. Many of them, I'm sure we can argue that they are violating Section 15, the Equality Rights, Section 7, the right to life, liberty, security. And there are many groups that are doing various or considering challenges to the new refugee law. Our clinic is still working on various challenges, including challenge to the LICO requirement in sponsorship. And I'm sure the new immigration criminality provision will be challenged once it becomes law. But launching a charter challenge is never easy, and it's even more difficult if we're talking about some of the most vulnerable population in our society. Because of their vulnerability, many racialized immigrant populations are very reluctant to take the government to court, and for good reasons. They fear retaliation if they do so. And many don't have the money, as mentioned, to hire lawyers, let alone taking on a constitutional challenge. The defunding of the court challenges program and the continuing underfunding of legal aid makes it impossible for many advocacy groups to undertake test case litigation. And for our community, the underrepresentation of racialized communities in the legal profession means there are fewer lawyers to work on these cases. And at the same time, many of our community members find it difficult to access the non-racialized sort of like legal services because of various barriers to access to services. While the specialty clinics that are set up to serve them don't have the adequate resources to assist them all. And I would add the lack of diversity of the bench. Judges don't always understand or even want to acknowledge the existence of race and racism. So all of these reasons explain why charter challenge initiated by racialized and immigrant communities are so few and far between. And in the context of immigration and citizenship law, charter challenges have actually not been helpful to advance the rights of immigrants. Since the Andrew case, which was the first equality right case that set out citizenship as an analogous ground, the rights for permanent residents has been gone downhill since then. The Supreme Court and the federal court in particular have really not protected immigrants from discriminatory laws. We are hoping, for instance, like with the criminality provision being tightening up even further by Minister of Kenney, potentially this is an opportunity for us to overturn some of the most ridiculous, decisions like the Chiarelli case of the Supreme Court. But given all these problems, why do we still use the charter litigation to push for social change? Well, because it is a tool, and sometimes it is the only tool when the government does not respond to us, when we don't have the political clout. And if you read some of the polls, when it comes to refugees, immigrants, as mentioned, the public sentiment is against them. So the court sometimes is our only resort, if not the last resort. So at the same time, I think it's also important because just by suing the government, we are sending an important message. We are exercising our democratic rights. And we are also sending a message to our community that our rights have to be respected, but we need to empower ourselves to stand up for our own rights because nobody else will. So that's my point.
Thank you, Avvy.